Hello, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service company. Today, we have a great webinar on a contractors, subcontractors, and suppliers step-by-step guide to getting paid in Nebraska by construction lien law experts Daniel Weidner and Casandra Langstaff. Without further ado, I would like to introduce Daniel Weidner and Casandra Langstaff.
Hello, everyone. Thanks for joining us today. In the next half hour, we're going to take some time to go over a step-by-step plan associated with improving chances of getting paid on a construction project. Some of this stuff is unique to Nebraska. Some of the stuff is just a matter of being, an avid, advocate of your business and the amounts that are owed to you. And so what we're going to do today is we're going to go through our top 5 kind of action items to improve your chances of getting paid. And then following that, we'll leave some time for questions. As you can see on the screen, if you have any questions, you can feel free to put them in the chat box on the right. And then, as we said, we will definitely leave time to answer them. And with that, I'm going to turn it over to Cassie to start talking generally about what the roadmap will look like to successful collection.
Awesome. Thanks, Dan. Yep. So my name is Cassie Langstaff. Dan and I are very well versed in collection efforts. We work with a lot of contractors in pursuing collections on projects. So we've kind of honed it in on 5 recommendations that we have to kind of improve your chances of prompt and complete payment on projects. We know that you guys work very hard in your craft, and of course, everybody wants to get paid. So we'd like to share just some tips we've come up with to make sure that happens. And like Dan said, we'll be sure to answer any of your questions at the end. All right, so I'm going to cover step 1. And the first best practice that we came up with actually starts at the beginning of the project before any work is even done. And that is to enter into a written agreement with your contracting party. Having a written agreement, even though construction agreements can be verbal, is a best practice, because having a written agreement prevents the he said, she said of a verbal agreement, and it's just much more easy to enforce if a payment dispute does come up. In your written agreement, we do recommend having specific payment terms that are clear and outlined. Some key terms we think you guys should consider incorporating into your agreements is timing considerations. A very normal, payment period, for example, is payment within 30 days of invoicing. Really laying that out in your agreement will help your collection efforts down the road in the event there is a dispute. Also consider being able to recover interest if there is a late payment. Sometimes even just using that as leverage when you're negotiating, you can say, I'll waive interest if you'll give me payment within a week. So it just kind of creates another nice leverage point. You can also consider laying out the method of payment that you prefer. I've seen where I have clients say when they're willing to accept credit card payments over the phone, for example, that sometimes increases their likelihood of getting paid. And then one final thing to consider adding into your written agreement is incorporating the right for you to suspend work in the event that you're not getting paid. If you can agree in writing to these key payment terms at the outset of a project, you're already teeing yourself up for success in your collection efforts in the future, because it's really hard to dispute the plain language of a written agreement. And it's, with a verbal agreement, things get fuzzy and recollections may vary. So having a clear written agreement would be our step number 1. All right, for step number 2, so after the work is performed or in progress, depending on the project, the next best practice that we came up with is to create a system for timely and consistent invoicing. So your invoices should be detailed. They should include, details of the work that was performed. And most importantly, they should be timely issued after the work was performed. So try to get your, accounts receivable department on board and get a good system in place for getting those invoices out the door. A common excuse when I'm pursuing collection efforts from someone who isn't paying is they say that the bill came as a surprise, and sometimes that's due to bad communication from the contractor. So providing these invoices and really laying out what the work what kind of work was performed can be super helpful and increases your likelihood to collect. Ensure that these invoices go out timely and make sure that they're consistent with that written agreement that we just talked about. For example, if the written agreement says payment terms are payment within 30 days of invoice, make sure that is included on the invoice that you're expecting payment within that 30 days. Additionally, if you have the right to recover interest in your written agreement, make sure that's laid out in the invoice. Just make sure that those are consistent. And then finally, just keep track of your collection efforts. Really try to make sure you have a paper trail of when the invoices were sent, who they were sent to, and that will be super helpful for your future collection next steps, which Dan Weidner will tell you about.
One more, continuing off that, as far as documenting your collection efforts, it's really important to do that so that you know when it's appropriate to follow up and you know that you are following up with people. And so this really requires a timely follow-up on delinquent payments, which you need to know when the invoice was issued, when it was received, and then come up with an appropriate protocol for following up. By coming up with the appropriate protocol, it gives you kind of the opportunity to have multiple bites at the apple. And the cliche saying, the squeaky wheel gets the grease, absolutely applies in collection. And so when you're determining how to follow up, oftentimes we're helping clients weigh, should you be following up with this customer via a phone call, via a text message, or does it need to be something more formalized as an email or a standard written letter? With regards to clients that you have a long-term working relationship with, oftentimes it's just a phone call or a text message that can shake things free. But with relationships that are starting to get a little bit rocky or not going well, we often believe that it's important to follow up via email or a letter, because that kind of elevates the importance of the matter and shows that you're taking this seriously.
Excuse me, Daniel. I am so sorry,
Yes.
I apologize. We just have a technical issue that I want to bring up. If you don't mind, on your screen where you go to display settings, can you click on switch so we can see your image better? Switch screens. Perfect, because yes, now it's much clearer. Thank you so much. Continue, so sorry.
No, we appreciate the heads up. Thank you so much.
Thanks, Anna.
So with respect to the following up, another item that can kind of elevate the level of seriousness that matter is given is by advising the other side that if you do not receive a timely response, that you're going to have to involve your legal counsel down the road. Now, in that regard, you need to ensure that you don't make that threat every single time. Otherwise, you will become the boy who cried wolf, and people will stop taking the threat seriously. But to the extent that you do have people that are slow paying you, and you can use that threat to get elevated timing of payment, it is definitely a good threat, which transitions us to our next talking point. And that's, as you're going through the efforts of determining how to get paid and when you're entitled to payment, you want to be familiar with your state's lien laws and timeline. The reason being is that a lien can be your insurance policy to give you the best chance of getting paid. In the state of Nebraska, you have 120 days from the date that you last provided material or service to a project in order to record a lien with the Register of Deeds in the county where the project occurred. And being cognizant of that, it will help you set an appropriate timeline for following up with the client and also ensuring that you do not miss that deadline, because that 120-day deadline is a hard and fast deadline. On day 121, you have no rights to record a lien. And that deadline, while it is extended each time you provide material or labor to the project, we always recommend to clients that they take it from the last time they've done substantive work on the project or provided substantive materials. In other words, you can't simply go back out to a project site and tighten one screw half a turn to reset your clock. You want to know when your deadline runs. And as you're marching up towards that deadline, you have a number of options to improve your ability to get paid. Option one is the statutory permissive ability to issue a notice of intent to file a lien. And what I mean by that is that in Nebraska, you are not required on most projects to issue a notice of intent to file a lien. It's permissive under the statutes, meaning the statute says that a contractor may do this, but the reason that you might want to do it is it, again, gives an elevated sense of concern to the project where the owner or the general contractor now knows that if you don't get paid, you're aware of your lien rights and you may record that lien. Now, the next thing that we want to consider is how does filing this lien impact the project? If you're working on a commercial project, oftentimes that commercial project will be done with a construction loan in place. And so the filing of the lien may bring the ability to have further loan payments issued to a screeching halt. In other words, once that lien's filed, the lender doesn't issue any additional payments for the project as a whole until that lien's resolved. That will cause the owner or the general contractor to give your matter increased attention. The other great thing about that is that oftentimes when these projects are getting to substantial completion, the owner is going to want to take that project and flip it from a construction loan to permanent financing. If your lien gets in that sweet spot between the switch, you will almost ensure that you will be paid and paid promptly and in full by recording that lien, because they'll be stuck on their construction loan unless and until they get your lien resolved or they bond over the lien. But that's a conversation for another day. And then the final consideration with respect to monitoring your deadline to file a construction lien and filing it as needed is be aware of whether there are other methodologies upon which you could receive payment. On public projects, there may be a payment bond in place that allows a claim to be made against the bond, where you would not actually have a lien on the property, but you'd have another mechanism through a surety where you could get paid. So step 5 is really turning the matter over to legal counsel. And at this point in time, you're usually doing this because you're getting no response from the individual that owes you money, and you're left with little to no choice but to involve legal counsel to ensure payment. The steps that we often take as legal counsel is we will start with a demand letter, and we will take the information from the client related to the contract, the work performed, the invoices issued, and the amounts owed, and put that all into a letter that addresses the fact that this money is due and owing, and that if it is not paid timely, our client may have no choice but to move forward with a lawsuit. What we oftentimes do, consistent with my prior comment about giving yourselves as many bites at the apple as possible, is we provide a short time frame to make payment to our client, something around 7 to 10 days. If we don't have a response within the 7 to 10 days, we'll oftentimes follow up with an email asking when we can expect a response, or we'll follow up with a phone call. Consistent with what Cassie was saying, we often like to add a little bit of a carrot to these demand letters as well. And so when we have the opportunity, either under a good contract to recover interest on behalf of our client, or because the amount owed is liquidated and we can attempt to recover interest under one of Nebraska statutes, we will take the time to explain the amounts owed. We will also calculate the interest due based off of the time when payment was required under the contract, and then offer to waive that interest in full if we receive payment within a week. When we find that when debtors take the opportunity to look at not only the outstanding balance, but that now the balance has increased by $1,000 or $2,000 or maybe significantly more, they're more inclined to pay you quickly, knowing that it will get them out of the potential to have to pay even more down the road. And then, candidly, if the phone calls and the emails and the demand letters don't work, you have to go through a process of weighing the cost and benefit of filing a lawsuit. When you're going through that analysis, it's important to talk to any legal counsel that's assisting you about what the cost of the litigation will look like, and whether there's any potential to recover attorney's fees. In most instances that this group is going to be dealing with, the opportunity to recover attorney's fees is going to be very low, meaning that you won't be entitled to them, and any attorney's fees that you incur in collection efforts are essentially sunk costs that you'll never be able to get back from the other side. A conversation for another day would be whether or not the Nebraska Prompt Payment Act applies such that you could give yourselves the leverage to potentially recover your attorney's fees. down the road. In addition to analyzing the cost of the lawsuit from a cost perspective from what you will owe your attorney to prosecute that, you also need to analyze whether there's been allegations of defective work or work that was not performed in a good and workmanlike manner. Because to the extent that there have been allegations of that, you can almost guarantee that once you file a lawsuit, you will receive a counterclaim in that lawsuit associated with that defective work. And depending upon the amount of controversy, the mere requirement to defend against that counterclaim can cost more in attorney fees than the amount in controversy or the amount that you're attempting to collect. So these are all conversations that should go on with legal counsel well in advance of making the determination to file the lawsuit. While everybody wants the money that they're entitled to, a good attorney is going to help you not only make a good legal decision, but help make a prudent business decision by analyzing kind of dollars in, dollars out, and what's it going to cost to get to the objective of collecting the fees. And there may be times where you should be talking to your accountant about, does it make sense to write the amount off and take it as a loss on your tax returns, because it's going to cost more to collect than what you hope to recover even with interest.
Well, perfect. With all that information we just threw at you and all that in mind, please let us know if you guys have any questions. I believe Diana's going to convey those to us, and feel free to fire.
At the moment, Cassie, I do not see any questions on the screen, but they could be, feel free to email us or call us anytime with questions, guys.
Perfect.
Absolutely.
Awesome. Well, also we have here a QR code. We love your feedback, so please take a moment to review us and let us know your thoughts, and we hope this was helpful today.
And then we've got a series of webinars that we're doing with SunRay throughout the rest of the year. We'll do one each quarter, and they will be presented either myself and Cassie or another individual on our construction team, Taylor Hayes. We all work at the law firm of Koley Jessen. I am the head of our construction practice area, and on the majority of my large construction disputes, I tag team them with either Cassie or Taylor. So we are happy to answer any questions that may come up, and look forward to the opportunity to help you navigate the construction industry a little bit more smoothly.
All right.
Perfect.
Well, thank you. Thank you very much, Dan and Cassie.
Thanks, Diana.
Thank you.
Thanks all.
You have a good day, everybody.
You too.